You're listening to the Agony Column News Report featuring interviews, phone interviews, reports from live book events and festivals, and conversations with readers. You can find additional news, interviews, book reviews, and more 5 days a week at the Agony Column website at trashotron.com/agony.
The justices built their judicial philosophies on the foundation of their prior lives. From differing perspectives, Ginsburg and Thomas had long experience with, and strong feelings about, civil rights. Roberts had neither. Breyer had given years of thought to the role of the administrative state. Roberts had not. Scalia endorsed an overarching theory of the Constitution. Roberts did not. Kennedy viewed the Supreme Court in the context of an international community of judges. Roberts saw no such thing. But the Chief Justice had spent decades thinking about how to throw plaintiffs in civil cases out of court. The faster, the better. Civil procedure, so dreary even to most lawyers, was for Roberts the surest route to victory for his political side. One of Roberts' fellow conservatives on the D.C. Circuit used to offer his law clerks a small cash bonus if they could find a procedural issue in any case that would allow the court to dismiss the action. Roberts provided no such cash incentives, but he shared the impulse. The real-world implications of these procedural roadblocks were clear. With so many barriers at every stage of the process, plaintiffs' lawyers hesitated before bringing new cases or did not bring them at all. The costs and risks were too high. Legislative efforts at tort reform, like limits on punitive damages, compounded the difficulties for plaintiffs. If claims could never get to trial because of procedural barriers, there would be fewer cases brought in the first place. This was especially true in civil rights cases, in public law cases, in Shea's phrase, because these ambitious undertakings had the greatest procedural vulnerabilities. The defense bar understood these economic realities and, with a sympathetic judiciary, pushed to capitalize on its advantages. As a lawyer and judge, Roberts was more skilled at this kind of work than anyone, all of which helps explain the fate of Lilly Ledbetter.
Jeffrey Toobin is a staff writer at The New Yorker, senior legal analyst for CNN, and the author of Opening Arguments, The Race of His Life, A Vast Conspiracy, Too Close to Call, and The Nine. His new book is The Oath, The Obama White House, and the Supreme Court. Thank you for joining me, Jeffrey.
Hi, Rick.
In these two books about the Supreme Court, and I think in all of your books, you're doing something really interesting. You're...
Sample complete. Ready to continue?